Okay, let's get started. Good afternoon and welcome to our second session in our monthly SALUS GRC webinar series. Today's webinar, Proactive Compliance Strategies, will cover hot SEC topics, SEC sweeps, status of rulemaking, implementation steps to think about, training, exam prep, and more. Starting with introductions, I'm Jackie Hallahan, Chief GRC Officer, Governance, Risk, and Compliance here at SALUS GRC. For those who are not familiar with SALUS, we are a fast-growing compliance and cybersecurity service provider founded on our unwavering commitment to provide excellence in customer service and expertise. Our experienced team provides ongoing compliance support, targeted projects, annual reviews, mock exams, cyber services, and help implementing new rules. Turning to my co-panelists for introductions, let's start with you, Jim.
Hi, everybody. Thanks for joining. I'm Jim Anderson. I'm a partner at the law firm of Wilkie, Farr & Gallagher, and I head our regulatory and compliance and enforcement practice on the asset management side. It's a group of about 35 attorneys. I began my career at the SEC as a staff attorney, and I'm now starting my fourth decade in private practice, dealing with the kinds of issues that we're going to talk about today. And given the depth and breadth of our practice, these are the issues we live with every single day. So I'm delighted to get to talk to everybody about them.
Great. Yes, then thank you everyone for joining. I'm Sanjay Lamba, Associate General Counsel at the Investment Advisor Association. Prior to joining the IAA, I too spent some time at the SEC. I was there for 10 years, first in the rulemaking division, Division of Investment Management, and then I spent the last 4 years in what was then referred to as the Office of Compliance Examinations and Inspections, OC, now the Exams Division. I was in their Chief Counsel's office providing legal support to examiners. My practice prior to joining the SEC, I was in private practice. I've been doing investment management law this whole time. And so delighted to be here. And thank you, Jackie and SALUS GRC for inviting me. So.
Great to have you. Our next slide. So our agenda for today's webinar, we're going to cover why proactive compliance and the SEC's emphasis on this topic. Sanjay is going to provide a detailed update on regulatory rulemaking, and we'll have observations regarding the private fund rule, SEC's next steps, an update on the status of the cybersecurity and other pending rules, and what firms should be doing or thinking about. We'll talk about proactive approaches and techniques regarding current significant compliance topics, and then we'll wrap up with key takeaways. Now, I just have a few housekeeping messages. All attendees are muted to reduce background noise. Feel free to submit questions through the Q&A window on your screen. All questions, but if we're unable to, a member of our team will follow up. You will receive a recording and a copy of the presentation after the event. We do have 4 polling questions throughout the presentation. We appreciate your cooperation in helping us see insights into what the industry is seeing by your responses to the questions. At the end of the webinar, at the very end, there's a link to sign up to receive notifications of our future webinar series events if you're interested. And with that, let's begin. So why proactive compliance? I got very interested in this after hearing a few speeches, and this goes to the SEC Enforcement Director, Gurbir Grewal's 3 principles of proactive compliance. He's been at the forefront of articulating the importance of proactive compliance in recent speeches, including a recent speech on AI. The emphasis on being proactive highlights the need, in his view, for being intentional, forward-thinking, and anticipatory in nature. The 3 principles are education, engagement, and execution. Educated about emerging risks, enforcement actions, and business changes. Engaged, being collaborative with personnel in your firm and across business units. And then the 3rd principle, execution. Policies and procedures, controls, and as he says, adoption is half the battle, effective execution is critical. So, Jim, let's start with you on what your thoughts are about this proactive compliance theme, and whether I was curious of whether you think this is a shift from the culture of compliance, quote unquote, or from the historical focus of culture at the top, or what do you think?
So I think it is likely just another way of articulating the same principle, which is that the SEC is concerned about ensuring an appropriate compliance regime for regulated entities. And whether you describe it as a compliance culture or tone at the top, or you get more granular and you sort of drill down into what that means in terms of your ability to implement a compliance program that's effective, I think these are sort of the three elements. And you know, it's a tacit acknowledgement perhaps on the part of the SEC that education comes first on the list, given the pace of rulemaking and just the plethora of enforcement actions. Keeping up is a sort of Sisyphean task for many compliance officers. It seems like there are not enough hours in the day to do your day job. So maybe in part it's a plea to empower and provide resources for compliance officers. I also think it reflects a bit of frustration on the part of the SEC that they keep bringing these, you know, large enforcement cases, and yet there are issues that persist, things like off-channel communications. In his speech, he cited whistleblower protections and the idea that things don't get resolved. And then I think a real conviction on his part that this is actually the right way to do it. And I think experienced compliance professionals would agree that, you know, in an ideal world, they would be on top of all of the regulatory developments, all of the emerging business practices. They would be engaged with their colleagues in terms of how best to address those compliance risks at their firms. And they would fully execute all of the compliance policies and procedures and related forensic testing. So I think it's a nice ideal. It may not be quite so neat in practice, but I, you know, support Director Graywall's efforts to try and empower CCOs.
And Sanjay.
Yeah, no, I mean, I think that's sort of the key, right? I mean, anytime the SEC speaks, particularly officials from either enforcement or the exams division, I think it's helpful. I think it's helpful that they talk about sort of what the SEC's expectations are in terms of how firms conduct their compliance programs. You know, I when his speech first came out, I thought it was notable. I thought there were some interesting tidbits in there. But what he really does a good job of doing is sort of explaining sort of what are elements of what he refers to as proactive compliance. But, you know, I think these are things, Jim, I think you would agree that they're just general good principles, right? I mean, he talks about education and just making sure that compliance and legal folks within firms are monitoring and reviewing enforcement actions in SEC speeches. I know we talk to our members all the time, and that's a huge area of focus, right? Anytime you see an enforcement action or you hear examination officials speak, it's intended to send a message. It's intended to provide a sort of a guideline as to what exam staff and enforcement is looking at. You know, I think certainly monitoring enforcement actions and speeches are good. And, you know, I would add to that, and we'll talk a lot about the regulatory proposals that we have, and just making sure that you're sort of monitoring them and sort of reading them as they come along, because those also, if you read the releases, signal sort of what the SEC expects. I think engaging with personnel inside the business units. I mean, we've heard certainly exam staff talk about this. That, you know, an effective compliance program means that you engage with all business units within your firm, and including some that you may not have even thought of engaging in the past, right? I mean, it's just, I think what's becoming more and more clear is that you need to sort of engage with others within your firm, and I would also, again, you know, add to that. And again, I talk about all these rulemakings, and we'll talk more about them. But as part of this engagement effort, you know, you would also start using that as a way to sort of start socializing certain issues with others within the firm on issues that might be coming down the pipeline. I think the execution is to me probably a notable takeaway here. When I was in the exams division, one of the things that struck me is that most of the deficiencies, and I'm sure Jackie can sort of agree with this as well, really have to do with just firms failing to implement policies and procedures, right? And these are policies and procedures that they had in place, and they just weren't being followed. And what always sort of strikes me when I read some of these enforcement actions or I read about these deficiencies is oftentimes firms will have policies and procedures that maybe didn't need to be as detailed, or maybe they didn't need specific policies and procedures in this area, but they decided to have them, but they just weren't following them, or folks within their shops weren't following them. And to me, I think the key here is that you should be assessing your policies and procedures. If there are controls in place that others within your shop are not following, figure out why that is, and figure out whether you need a policy and procedure, or whether you need such detailed policies and procedures. You always hear about exam staff. I think the worst thing you can do is to have a policy and procedure in place and not be implementing them. And I think his speech sort of lays that out. So I think it's a good read. I think something that you can show to others within your shop and show sort of like what the expectations are from exam and enforcement staff.
It's certainly hard, though. It's very hard, I think, with so many proposed rules out. And CCOs have their hands full anyway, just implementing their program. But to try to, we have a lot of clients who are like superb, proactive compliance officers. But then there are smaller firms that really struggle with this because they're trying to, like you said, they have a day job, and this becomes difficult. But there are good points for sure. Okay, so now, Sanjay, I think we are turning it over to you in the next slide to talk about, I think you and Jim are going to talk about observations regarding the private fund rule and next steps, and then what ideas what firms should be doing or are doing based on what you're seeing. And then we'll begin the update on all these rules, which is plenty. Thanks.
Yeah, did you want me to kick this off? Yeah. Yeah, so obviously if you're a private fund manager, there's a huge recent court decision that essentially just vacated or overturned the SEC's rulemaking for private funds. I don't think we're going to go into details as to what that rulemaking was, but certainly if you're a private fund advisor, it's something that you've been working through. I know our members have been working diligently to implement these rules, but now the Fifth Circuit basically overturned the SEC's rulemaking here. And, I think, Jim, I'd love to get your views on this, but to me, it was sort of surprising that they completely overturned the entire rulemaking. I mean, I think a lot of court watchers and a lot of people are observing that maybe bits and pieces of it would be overturned, but others would survive. But here, the entire rulemaking just went away. And I think the question now is, okay, what happened? So it's a Fifth Circuit decision. It's a panel of judges. It was unanimous. All the judges agreed on the decision. And the question now becomes, and the SEC has 60 days to appeal it. And so the question now is, what will the SEC do? Will they appeal the rule? Will they appeal this decision? I think to me, there's really a lot of issues for the SEC to consider. I think, first of all, it's clear that, we won't know until probably day 59 as to whether they're going to appeal it or not. But, the next step would be either seeking an in-bank rehearing before the entire Fifth Circuit. But again, as I said, the panel of judges here was unanimous, and I mean, all three of them voted against the rulemaking. And so I think, I'm not a litigation attorney, but I think many court watchers think that it's unlikely that the full court would even agree to rehear it. But even if they did, there's a very high risk in this instance that all the judges in bank would affirm the decision, which would make this decision even stronger, right? I mean, right now it's a isolated Fifth Circuit decision, very damaging to the SEC, but there's a risk there for the SEC. Now, the SEC could also try to go before the Supreme Court and seek cert there, but again, it's not the SEC's decision. My understanding is that the Solicitor General of the United States would have to make this decision, but so the Justice Department would have to be involved. But But given that there's no split in circuits here, it's one circuit decision, I think it's very unlikely that the Supreme Court would take the case. Again, this is just my opinion, but look, at the end of the day, this is a huge blow to the SEC's rulemaking authority in general. And I think there's a high risk for them to move forward, but I have no way of knowing what this administration will do on this. So, Jim, I don't know what your thoughts are, but
yeah. So I'm sort of the same. I think I was generally surprised that the rules that were adopted specifically with reference to 2064 got struck down as not having an adequate basis in the SEC's rulemaking authority. Just because historically, I think the SEC has viewed that anti-fraud rulemaking authority as pretty broad, and they've adopted a lot of rules using that authority. But that really highlights the risk. If you've read the opinion, you see that the Fifth Circuit sort of said that invoking anti-fraud authority for these rules was really just a pretext. And I think right now the SEC could take that opinion and say, the conversation about or the discussion in the opinion about fraud as a pretext really is just dicta and doesn't necessarily have a broader impact on the rules that they've previously adopted under Section 2064. But if they risk getting another opinion that may focus, more significantly on that issue, I think it does put other rulemaking potentially at issue and their authority. And the marketing rule is a good example where, the sort of broad prophylactic restrictions have a more attenuated connection to fraud than maybe would withstand scrutiny by the Fifth Circuit if somebody decided to challenge that rule there. You could probably say the same thing about the pay-to-play rule, which is also adopted under Section 2064, and such a broad prohibition on political contributions to get at a few potential instances of quid pro quo could also be viewed as a pretext. So I think there's risk of appealing and getting a worse decision either en banc or from the SEC about the scope of 2064 rulemaking authority. So it wouldn't surprise me if we don't see an appeal, but I just have no way of knowing.
Yeah. But I think at a minimum there are sort of some key takeaways. I think the first question is, what should firms be doing with respect to these rules now, right? And I think what I'm hearing is that certainly there are elements of it that it would certainly be reasonable to stop implementing the rule, but there are certain elements of it I'm hearing that certain advisors or clients are starting to ask that some of these things that were required, that were being suggested to require, are now something that our clients are asking for. But look, I think each firm has to sort of make a decision as to where they are in the implementation process. But as of today, the rules have been set aside. We're waiting for the SEC to figure out what their next step will be. I think it also has implications for the other rulemakings that are out there, and we'll talk a little bit more about that. Because Jim, as you noted, some of the discussion in here really went to the heart of the SEC's rulemaking authority. The marketing rule, the pay-to-play rule you mentioned, custody. I mean, all these rules were adopted under these anti-fraud provisions, and now the court seems to be suggesting that the SEC needs to do a better job in its rulemakings of articulating sort of the actual fraud, right? That's being trying to address. So I think it's going to have implications for the rulemaking as well as in the pipeline.
Yeah, the other thing I would say about it is we've all seen how the SEC has ways to make law apart from formally adopting rules, and there's every reason to expect that the SEC will use the enforcement process to try and impose some of these standards. And we've all read examination letters that talk about best practices as though they were the law and criticize firms. And so I think there are plenty of ways for the SEC to play this back. And so if you're thinking about what do I do with all of the implementation work that I've done so far, I think it's worth a pretty thorough post-mortem of that effort and maybe maintaining some of those things, recognizing that the SEC doesn't necessarily need rulemaking to impose standards that they believe are best practices. And so it would, I think, be short-sighted to think that this is the end of the effort to impose these standards in the private fund world, notwithstanding that they don't have an actual rule to point to as the basis for those standards.
Okay. Sanjay, do you have any news on the status of the cybersecurity bill, proposed rule, or any of the other rules?
Yeah, so let's if I could maybe just sort of stand back and look, the SEC, I don't think it's any secret that under Chair Gensler's watch, the SEC has been sort of on I would call it a rampage of rulemaking. The SEC, by all accounts, is moving ahead with rulemakings that will really virtually cover a complete overhaul of the regulatory framework for advisors. And again, it's not clear to us, and we in the IA and each of our comment letters, we try to make this point. We're not really sure what problems the SEC is trying to address, but if you look at all these various rulemakings, they cover a wide scope of issues. But they are moving ahead. And I think what we're seeing is sort of, if you step back and you look at all these rulemakings, is that sort of there's a significant shift from what we like to refer to as a principles-based fiduciary framework for advisors, a regulatory framework, to a very prescriptive approaches. And so in terms of where we are on these various rulemakings, I'll start with cybersecurity since you asked me about that one first. Look, I think this is one where we're not really sure what the holdup is. I think we're expecting a final rule here. I've been saying any day now, but I've been saying that for months. We've seen other rules, cyber rules, similar rules, particularly for public companies, have already gone into effect. But I think, and again, I'm just speculating here as to what the holdup might be. There's been certain events that have taken place that maybe the SEC is sort of rethinking. Obviously, they got a lot of comments on it, on the proposal. We know that in Congress, for example, there's new bipartisan legislation that's been floating around for a national privacy bill that could preempt certain state laws. And we also know, I'm sure everyone on the call who sort of follows cybersecurity, the new NIST standards 2.0 have come out. There's some elements in there as well. So, what was the most controversial aspect of this proposal? It was the requirement that firms report within 48 hours a significant incident. So I think, look, I'm not going to go out on a limb, but I think a lot of the comment letters that came in said that was too quick of a reporting requirement. So I could see maybe the SEC changing that to 72 hours or 4 business days or something along those lines. But look, I think that this is a rulemaking that I'm not sure what the holdup is. I think the reporting period, I think that's sort of probably the big issue, but I would imagine that the SEC can sort of resolve that and come up with a final rule. So I'm expecting a rulemaking really any day now. I keep saying that, but we'll see where that goes. I also just mentioned the predictive data analytics proposal. That's one that I particularly have been focused on. Just by way of background, this is a proposal that deals with conflicts of interest in connection with the use of what the SEC defines as certain cover technologies. And then I'm also going to lump that with the safeguarding, which is a significant amendments to the custody rule. It's a complete rewrite. On those 2 rules, Chair Gensler has come out publicly and said that he's asked the SEC rulemaking staff to come up with recommendations to repropose these rules. And I think that's a huge win for industry, because particularly the PDA proposal got a lot of negative comments. It was very broad in scope. It covered virtually every technology, and it was just a rulemaking that just got a lot of negative comments. So our understanding is that the SEC staff is working on reproposals for both safeguarding and PDA. So so we should see a reproposals of these rulemakings in the future. Outsourcing, this is another one that got a lot of feedback, a lot of comments. again, I'm not sure about the timing as to the outsourcing proposal. We expected it, and by all accounts, we were sort of hearing a buzz that was coming out by the end of last year. But really, quite frankly, all the buzz has died down here in DC on that one. But it is an extremely complicated proposal. And I think the one thing I'll point out is that a lot of these proposals are interrelated. And I think that's something that the SEC hopefully is also considering, is how these various proposals interrelate with each other. For example, the outsourcing proposal have a lot of provisions on how you'll be able to manage your contracts and your arrangements with service providers and vendors. And so I think hopefully what they're doing is that and there are similar provisions, for example, in the safeguarding proposal. And so I think hopefully what the SEC is doing is taking a step back. We certainly, in our comment letter to the SEC, recommended that they look at how all these rules interrelate with each other. But hopefully they're looking at the outsourcing proposal in connection with all these others and figuring out how they're interconnected. So that's the state of play of the SEC proposals. I don't know, Jim, if you have any, or Jackie, if you have any additional thoughts on that.
The only thing I would add is, we are in an election year. We're coming down towards the end of kind of whatever the current regime is, and among other things, under the Congressional Review Act, Congress, that if there's a new Congress in January, can review any rules that were adopted during the last 60 days of the legislative session, which now it's kind of hard to believe that we're at the 1st of July, but there are probably less than 60 days left in terms of actual business days when the legislature will be in session. And so any rules that get adopted now will be subject to that review process. And there's a bit of a risk for the SEC in adopting rules if there is a change in Congress where those rules could be overturned as part of that rule process. I think in the last Trump administration, there were 16 or 17 rules that were overturned as part of that process, and you might expect more. If a rule gets overturned under the Congressional Review Act by Congress, which allows them to look at any major rule adopted within those 60 days, you can only have rulemaking on that same topic if it's specifically authorized by Congress. So the SEC has some challenges in terms of their rulemaking agenda for the fall as we anticipate the election, and maybe we'll see fewer rules adopted than we would if we were in a year away from the end of President Biden's term, as opposed to moving up on an election.
Yeah, no, I think that's a great point, Jim. I think the election obviously is sort of the goalpost here, and I think what we'll see is really starting probably next month, we'll start seeing a rush of rulemakings that do get adopted, just to avoid the implications of that Congressional Review Act that you mentioned. But again, I think there's so many rulemakings out there, and I'll show you a chart that sort of magnifies that I think it's going to be really up to the chair to set priorities in terms of which rulemakings they want to get across the goalpost. Look, I'll also tell you that the SEC has staffing issues, right? I mean, you have to put SEC staff on each of these rulemakings. There's so many of them that it's going to be a lot of work for the staff to try to get through. And so I think it's really going to be a matter of the chair prioritizing which rulemakings they want to get across the goal line here before the election. But I think that's a great point. I think the other thing I didn't add is, I think the Fifth Circuit decision on the private funds rulemaking and the threat of litigation is also has to be front and center in the commission's mind, right? I mean, I think particularly, for example, like the PDA proposal, which there's been so much negative backlash, there is a threat of litigation as well. And so, and I think, as I said earlier, the SEC has to sort of take a look at the court's opinion and whatever final rules they come out with, sort of, are in line with some of the discussions in there regarding rulemaking authority as well. So
it does make it very difficult, though, for the advisors, because you're trying to be proactive and keep up with the changes that are happening, and then be ready to implement, think about it in terms of best practices. I think it makes it really hard, very tough environment for this. What are you hearing about DOL?
Yeah, no, just real quickly, so the DOL released its final amendments to the definition of fiduciary advice under ERISA. And so they made several important changes. They clarify and narrow the scopes of circumstances in which a recommendation would be considered fiduciary advice. And they did, happily, and this is something that the IAA commented on, reduce some of the proposed documentation, record keeping, and transition burdens. But there's a lot there to digest. In the Federal Trade Commission, I think by now everyone has heard, they've implemented a ban. They proposed a ban on employers using non-compete clauses. Again, we submitted comment letters, and we're really analyzing what those implications are. But I think the key takeaways here is that the final rule applies to all businesses and all workers. So in other words, this ban would apply to whether paid or not paid individuals who work for the employer, as well as independent contractors. There are no exceptions for regulated entities such as investment advisors. And the final rule applies to existing non-compete agreements. So look, I think the takeaway there is that given this final rule, you need to take a look at your agreements and making sure they're in line with sort of the expectations here. And then the only other thing I'll mention, and again, the key I think the takeaway here is that's not just the SEC rulemaking that advisors need to keep track of. You have DOL, you have the Federal Trade Commission, and now you also have Treasury Department that's proposed a series of anti-money laundering and requirements, and sort of know your clients, know your customers. And that's something that would capture all advisors, their compliance programs. You would have to have now anti-money laundering programs in place to the extent that you already don't. And so these are some other rulemakings that are on the horizon. Jim, I don't know if you wanted to add anything before I go to the next slide. Or...
Yeah, I think we should click over to the next slide. That was a good overview.
Polling question, yeah?
Oh, we have a polling question. So, have you been planning internally for the cybersecurity or other pending rules with the expectation that the rules will be adopted even though with changes? So we're just curious how many firms have been moving along in terms of implementation, or whether you're going to you're waiting for the rule to be adopted first. So it'd be an interesting look. So while that's running, don't see that yet, but Sanjay, here we go. Yeah.
Okay. Yeah. So we thought it'd be we at the IAA, part of my job and part of our job is to advocate, and we write comment letters, and we're talking to the SEC staff as well as the commissioners. And we put this chart together and submitted it in one of our comment letters where we asked the SEC to consider how all these rules are going to impact advisors. I know you can't read it. We have this chart on the IAA's website, so feel free to go take a look at it. But what this chart is we went back since Chair Gensler came into office, and we pulled out all the rulemakings that we feel will have a significant impact on investment advisors. And we listed them here. And then we took what the SEC was proposing to be the compliance periods for each of these rules, and we put it into this Gantt chart. Now, what this chart is designed to show you, and I think it's pretty impactful, is that over the next 3 years, if these rules and when these rules start to get adopted, this is what your implementation timeline will look like for all these various different rulemakings. Now, just to put it into perspective, for the marketing rule, the commission gave advisors 18 months to come into compliance with one rule. What you see here are over 20 rulemakings that will potentially have to be implemented during the same time period. I think going back to the whole notion we were talking about earlier of just sort of monitoring these rulemakings, I think traditionally, understandably, compliance folks would kind of take a look at rulemakings and say, we have so much on our plate right now, we'll worry about that when it becomes implemented and when the compliance period kicks in, and then we'll worry about it then. I think that's going to be really hard to do in this instance. I think looking at what's on the horizon, this is a very sobering chart, but I think you almost have to start planning for implementation of all these various rules over the next three plus years. So I thought this chart would be helpful just to sort of, I know the topic today is proactive compliance. If you're looking at proactively what's down the pipeline for the next 3 years, this is what everyone's going to be facing.
Yeah, thanks. So our next slide. We have another one. This is on AI. What best describes your firm's current use of AI? So whether you've adopted policies and procedures for the firm and employees' use of AI for business purposes. The second one, whether people or employees are using AI tools informally, but not being integrated into output for the firm's business, or you have adopted policies prohibiting its use, or their last choice is you have not considered AI in the business. This is a very hot topic for the SEC, so it's interesting to see where, how many firms are involved in this. I know that was also discussed in Graywall's speech when he was talking about AI in terms of the growth between investor interest and business interest. So it's interesting to see where firms are in terms of policies, developing policies and oversight. But we can talk about that more. I know that's one of our hot topics. So okay. Oh, we got results already on this one. So 38. I don't know what you all think, Sanjay, but I'm a little surprised about this. That certain people are using AI tools informally, but not integrating output to the firm's business. That's 40%.
Yeah, I wonder about that. I feel like it's hard to know, right? I mean, I'm pretty sure that almost everyone at this point is using AI in some way in their business capacity, and so I would be a little bit nervous about. I would say that's probably closer to 100% of people are using AI, or but you just don't know about it, and so. But look, I think what this reflects is that these are early stages, but I think the speech that you referenced really was all about emerging risk. And I think AI is one has potential to be one of the most beneficial and helpful tools, but also from a compliance and legal standpoint, there are a lot of risk there.
I would say we're drafting AI policies and procedures mostly focused on the use of generative AI, where you have a different set of considerations if you are providing any of your proprietary information that could be used in some machine learning format, and also a sort of concern about what sort of stuff you get back and how people represent it. And so what if you're getting MNPI back through some generative AI platform? You can define the use of AI really broadly, and people don't have specific policies and procedures. But if you really are using it to conduct research and analysis in a generative format, I think it's worth thinking about policies and procedures, at least so the compliance officer has some control around what's happening.
Mm-hmm. Yeah, definitely from the exam side as well. I would think they're looking for procedures for firms, what they're permitting, and how are you going to supervise that? It's interesting. Okay, so our next topic is we're going to now turn to exams and enforcement priorities and sweeps, some of the bigger ones, and talk about this in terms of what have you been seeing. I know, Sanjay, the IA you had a lot of document requests. Jim, I know you do too on these. But I find it interesting to learn. I'm sure the audience would really like to hear about what are some of the ways firms are approaching this. I know, Jim, you and I talked about that in particular on off channel, but Jim, you want to start on the marketing?
Yeah, let me just tell one story about the marketing rule. Not really a story, an observation. You're starting to see cases come out on the marketing rule, and it goes to Director Graywall's observation about the need for education. There was a case about a week and a half ago against a firm called 20 Acre Capital that, if you were to look at it, seems sort of obvious. They had one non-restricted investor in a fund who was able to get IPO allocations, and the return for that investor was like 45%. And for everybody else in the fund, it was like -5. And they were touting the 44% return for non-restricted investors in their marketing materials. You could look at that case and kind of think, nothing to be seen here. That one seems obvious. But when you actually read the release, the one piece that's interesting, and I don't think it's a throwaway line, is a comment about the fact that there were, or a suggestion that there were appropriate disclaimers. They were just on the same page as the presentation about the 44%. So for somebody who's reading it and trying to figure out what's the SEC care about in marketing rules, I think it stands out as an example of a case where really the proximity of disclosure becomes critical to being able to withstand enforcement scrutiny. And I don't think they included the line about, not on the same page by accident. I think it was intended to signal to the investment advisory industry something about the proximity of disclosure. But unless you really read the sort of the fine print at the end, you would just miss that point. And so, it highlights the difficulty of education. But I also think it's, as you read the exam risk alert and you think about the issues that are emerging, even proximity of disclosure is one that comes up. So I'll just say that about marketing rule, and we can move on to talk about some of the others.
Yeah. Well, we've talked about private funds, but how about off-channel communications? Lots of activity there.
Yes, Sanjay, I don't know if you want to start there.
Yeah, no, if I could just maybe add sort of my take on the marketing rule, if that's okay. I thought the latest enforcement action was notable. It was the first time it's not involved an issue of, presenting hypothetical performance. All the enforcement actions we've seen to date involve firms that were using hypothetical performance, but most notably were doing it on their websites without any controls or procedures in place. And, I've been we've been, and I know there's some members here from the IA on the call, but we have a marketing implementation group. We've been meeting every 2 weeks to talk through implementation issues. I don't think that's any secret that this is a huge priority, not just for the examinations division, but I think what's notable here is that you have the enforcement division that's doing investigations on the marketing rule. I mean, traditionally in the past, you've had exams go out, do exams, and if there's deficiencies or if there's significant deficiencies, we'll have a referral to enforcement and you'll see enforcement actions. But what we see here with respect to the marketing rule is sort of a dual track approach, right? Where you have both enforcement and exams out there, making sure that firms are in compliance with the marketing rule. The exams division just put out a risk alert where they, for the first time, shared substantively their observations from the marketing rule examination. So I would encourage folks to take a look at that risk alert. It is limited in the sense that the risk alert focuses on the record keeping and the Form ADV disclosure obligations, and as well as the general prohibitions, the principles-based aspects of the marketing rule. I would expect at some point down the line to see another risk alert where the SEC exams division will talk about some of the various other provisions that, particularly some of the performance-related issues that I know our members have been struggling with, but a lot of firms have been trying to work through, particularly in light of the SEC staff's FAQs on gross and net presentation of performance. So, I would encourage folks to take a look at that risk alert. I do think the compliance with the marketing rule is going to be an element of all examinations. But as I said, it's not just exams that's looking at it. It's also the enforcement division. So.
Yeah. And I know when I think it was Natasha Greiner, when she was with exams at the end, was talking about, it was really a very clear message to the industry saying we are going to be examining in every exam marketing. So, I mean, in terms of being proactive, you really need to be expecting that for sure. Absolutely. So what about off-channel? Jim, do you have comments there?
I think everybody's heard about off-channel till they're probably sick of it. It's still not going away. I think there are probably some a fair number of cases that are in the pipeline based on things we've seen and heard and that we're aware of. It remains a compliance challenge, even with technological solutions. And so I think it's just going to remain a priority until people actually get the issue resolved, which maybe never. But certainly, the three principles of education, engagement, and execution seem critical to trying to address that issue.
Yeah. And it seems that there are many ways that firms are trying to deal with this in totally different ways. Whether it's two phones or testing personally their use of off-channel communications for business purposes. But what are you hearing about that, Sanjay, from in the IAA in terms of outreach?
I'm not sure what you mean, but but I think what I'll say about this is that obviously we've seen the enforcement actions. The issue's been around a while. I think this is probably something that hopefully by now advisors are really attuned to. I do feel like what I'm hearing is that it's become a routine part of all examinations now to ask about controls around off-channel communication. So look, to me, it's sort of about takeaways from these cases. I think certainly you should be reviewing your policies and procedures, and if appropriate, you should also be thinking about ways to improve record-keeping related policies and procedures. Understanding that the SEC staff clearly expect firms, advisors to maintain and retain all business-related electronic communications. And again, going back to the whole notion of implementing and making sure that the policies and procedures are being implemented, particularly with respect to monitoring, surveillance, and supervision. And then look, we haven't talked about this, but I do think there are elements about expectations on self-reporting violations in this area, and I do think there are pros and cons, but I would highly recommend firms consider the cons as well as any potential pros. But the SEC has clearly made clear that they will consider as part of any settlement any firms that sort of voluntarily cooperate with investigations. But I think one other takeaway is that if you do have issues that you find in your testing around off-channel communications, you should promptly remediate these record-keeping issues, and you should be updating your policies and procedures. So, I think at this point, it's pretty clear that this is a major focus for examinations as well, and I just think it's going to become a routine part of the examinations.
Yeah, and we've talked about AI. So, Jim, can you share with us about whistleblower? I know you had a lot to say here.
Yeah, well, if you go back to Director Graywall's speech, which is sort of the theme of our presentation today, he actually uses whistleblower as the example for education, engagement, and execution. And he talks about the fact that there are a bunch of cases, including the D.E. Shaw case, where they imposed a $10 million penalty for having employment agreements that violated, in the SEC's view, 21 F-17 of Dodd-Frank, which is the whistleblower protection provisions of Dodd-Frank. So I think he was clearly trying to signal in that speech and just giving that as the example that that's a priority and you should walk away from that. The engagement he talks about needing to involve HR and others as part of an effort to make sure that you're compliant, and then finally the execution of monitoring those agreements. So following that speech, the SEC has begun a sweep. They're out through the enforcement division. They are requesting that the subjects of that sweep provide all of their agreements that impose confidentiality provisions on the counterparties to those agreements. Our clients have a handful of them. we've been pretty successful in negotiating back the scope to only agreements that involve natural persons. I think the best reading of 21F17 is that it really only applies to natural persons, and a legal entity couldn't be a whistleblower. But you would be surprised at the scope of agreements that the SEC is looking at. So it's not just employment or separation agreements. It includes, for example, limited partnership or subscription agreements where there might be confidentiality provisions, and a broad scope of other kinds of non-disclosure agreements have been requested as part of that effort. So, if you were going to take away a lesson about proactive compliance, I think the message Director Graylaw was trying to send was you ought to be looking at the agreements that you have that would be implicated by 21F17, doing an inventory, and then amending those agreements to make them compliant. And to the extent that they impose restrictions on the ability of any individual natural person to communicate whistleblower issues to the government, you need to amend those agreements to eliminate those restrictions. Or in most cases, our clients who are working through this are adding sort of savings clauses that say, notwithstanding anything to the contrary herein, you can, of course, report violations of the law to government agencies without advising us in advance and without other restrictions. So I think, it's an example where we've now seen through the speeches, through the enforcement cases, and now through the sweeps that they're following through on that, and smart compliance officers are getting in front of those issues because I think there are going to be more cases.
Yeah. Okay. Our next slide. I think we are we have another polling question. On whistleblower protection. This is whether you have reviewed and revised your agreements, or that the last choice is you're not aware we need to look at these agreements. So, Jim, I think that was really great information you shared. Be very helpful to the firms here. In our last, looks like 6-7 minutes, we have the list of the hot topics. We've covered most of them in the prior slides, but there were a couple of things we wanted to talk about. I know training, Jim, you were talking about that in terms of how critically important that has become. And we also wanted to talk just briefly about self-reporting. That was an interesting dialogue about should you or shouldn't you, or what are the firms thinking.
Jay, we got a question in the chat box that I think might be helpful just to clarify, if I could. The question is all off-channel communications with clients prohibited, or just those that are present a conflict? And just to clarify here, what the SEC is saying is that you have record-keeping obligations under the record-keeping rule to maintain business-related documents, specifically those documents that are in the record-keeping. Any off-channel communications that would be deemed a required record are required to be maintained. So the issue really here is about making sure you have policies and procedures in place and monitoring and control over record-keeping obligations that might be implicated by any off-channel communication. So I just wanted to clarify that.
Okay, so we have a good percentage of people who haven't done it yet, or haven't reviewed or revised or weren't aware, and 28% have been going through this process. So that's great information for a number of advisors attending our webinar. Turning to the next slide, Jim, you want to just touch briefly on the training topic?
Yeah, the thing I would say about training is that it's never been more important as the element of education, and the critical piece of it is the consistency, but also the scope of training. And not everybody in the firm has to be trained about everything, and so tailoring the training to issues that are appropriate to particular audiences, I think, improves your training program. And so being thoughtful, for example, if you've got want to do a training about valuation, or you want to do a training about expense allocation, those are perhaps topics that are better reserved for back office or accounting personnel. And I think you can be more successful implementing training programs if you don't try and impose them firm-wide, but you have more focused training programs tailored to particular audiences. That's what I'd say about that.
Great. I know, Sanjay, you talked briefly about the self-reporting, but we only have a few minutes left here. And I think that kind of also ties to the remediation discussion about the SEC. Are they expecting clear guidelines now on how you're going to handle problems that you've encountered, such as, well, I think the example we were talking about previously were, if you have a problem with your fees or expenses, and they're looking for policies and procedures. Now, I've always seen, firms would have procedures on trade errors. You'd see that routinely, but I haven't seen many policies and procedures that are broader than that, talking about, because the types of circumstances would vary significantly from firm to firm. So, but I think the message here is to really think about that. And is it clear what you're going to do in what circumstance? I think that was really the gist of our conversation. Did you want to add anything, Sanjay, on the self-reporting?
No, I mean, I think this is an issue that's been around for many years. And I think Jim would probably agree that before you think about self-reporting, you should really think about all the implications and talk to outside counsel, call Jim up. But yeah, no, I think it's interesting that they still sort of talk about that.
Here's the funny observation that I had about it. If you read Commissioner Graywall's speech, he touts the benefits of self-reporting and explains that you get reduced penalties. He didn't offer a single example where they didn't bring a case, based on credit for cooperation. So self-reporting just about guarantees you a case. I'm not sure that's a good trade relative to hoping the statute of limitations runs or you've taken corrective action and you'll get most of the same credit anyway.
Well, that's great. And I think all of these things that we're talking about here in terms of being proactive are really helpful in terms of being better prepared for an SEC exam. Or doing targeted testing on particular issues that are of concern to the SEC. Being able to do things like that proactively will really help. And then in our last minute or so, our key takeaways for parting thoughts to the audience about, we've talked about rethinking approaches of how you're doing things and staying current with rule proposals and the important role of being very aware of the priorities and what's happening in the risk alerts and what about the enforcement cases and sweeps going on and how planning and preparation is key to the successful outcome of exams. So do you have any parting thoughts you'd like to share? Start with you, Jim.
Yeah, I think your job as compliance officers has never been more difficult. The thing we didn't talk about in Gabrier's speech is his comments about CCO liability, which were part of that broader discussion about proactive compliance. But the takeaway was that they're not trying to second guess good faith judgments made by informed compliance personnel who are operating responsibly. So even though it feels a little bit overwhelming, he did throw out a bone to compliance officers and a recognition that you're doing good work and the SEC is not looking to punish you as you continue to act in good faith and do the best you can.
Yeah, I mean, I think I agree with that. And I think to me, sort of the two takeaways, and we've talked about them throughout. One is that, just really being attuned to all the rulemakings that are in the pipeline. And just recognizing the fact that notwithstanding what we talked about in terms of which rules they can get across the board before the elections or any potential for overruling the rules, I mean, there are certain rulemakings that will come into effect that will impact you significantly. And I think it's important for firms and particularly CCOs to start thinking about those now. So like, for example, the cybersecurity reporting elements, there will be a reporting requirement. So start thinking about what that means for your program now. A lot of the various rulemakings are going to have requirements in terms of vendor arrangements and agreements. So start taking a look at your vendor arrangements and see what's in play. So I think, This is not a time for just sort of set and wait for the rules to come into effect. I think you need to start proactively thinking about it. And the other is training. We talked a lot about training and just start socializing these requirements with folks within your firm, but just also training them as to what the requirements are. Look, the marketing rule, I think, is a good template. There's nothing in the rule itself that requires a training program or policies and procedures around that, but clearly we've heard the SEC staff say publicly, and we know that in examinations, they're asking firms about their training and how they're training employees. So I think that's critical to consider training as part of your compliance program, and to start thinking about how you can improve your training programs.
Well, thank you both so much. Really fantastic information, great panelists. And thank you for your time, and thanks to our great audience. Don't forget to register for our monthly webinar series covering all of these evolving topics and new rules as they and all with exceptional panelists and practical tips. It was really, really terrific. Thank you.
Thank you.
Thanks.